worldwide. As it is becoming an immense and conflict resolution has to be facilitated by a dialogue with long-term focus, by way of good communication platform, and acceptable dispute resolution mechanism adopting global standards. The essentiality can be concerned down to basic research and promoting institutionalism of ADR, which is a state-of-art infrastructure and which is a tailor-made rules, regulations, and execution of diversified training professionals. In order to cater such elite needs, KFCRI provides to set up a center for arbitration, conciliation, mediation, as well as negotiation, with a special focus on mobilizing ADR practitioners and, most importantly, tribunal secretaries with world-class training and accreditation, which is acceptable in various jurisdictions worldwide. KFCRI has actually been taking immense pleasure in welcoming Professor Kazushi for this wonderful webinar. And Mr. B. Intelligencer, he has been a career guidance for us. And Intelligencer was educated at Dr. Ambedkar Law University. And on completion of his legal education, he took up legal practice at High Court of Madras in 1997. And his enthusiasm towards ADR made him to pursue the whole time arbitration practice since 2001. He is currently the managing partner of Prof Global, and he has been presiding as a sole arbitrator and represented as a counsel over 300 domestic cases and several small claims, commercial arbitrations, and 14 international arbitrations. His area of practice includes his international commercial arbitrations, maritime arbitration, international trade and contracts, IPR, construction disputes, finance and banking disputes, security markets, joint ventures, etc. In addition to that, he has been accredited as an arbitrator in various institutions such as SIAC, HKIAC, etc. In addition to promoting the concept of ADR by way of writing articles and books, providing training courses, and giving lectures in arbitrations to the students of various law colleges and ADR in law schools, universities, Chamber of Commerce, etc. Thank you for joining us in this meeting, sir.
Thank you. Thank you, CP. Yes.
I take immense pleasure in welcoming Professor Kazushi to this, who is the chief guest of today's webinar program. And Professor Kazushi is a visiting professor at Tashkent State University of Law, a fellow of Central Asian Legal Research Fellowship, and an editorial board member of Tashkent State University of Law. He began his career at Nagoya University School of Law, where he earned a Bachelor of Law while also studying for the bar, and subsequently completed a Master of Law at Nagoya University Graduate School of Law. And his international collaborative research with Director of Kennedy Institute of Ethics of Presidential Kennedy Family of Georgetown University as a visiting researcher, and a university researcher of Georgetown. As a special lecturer at Nagoya University Graduate School of Law, he contributed to establish a law school as well as the Global Legal Assistant Project of Japan. He sanctioned in the Republic of Uzbekistan as Minister of Justice, and Tashkent State University of Law and Nagoya University Education, and Research Center for Japanese Law with Tashkent State University of Law as a lecturer of Japanese law. He has delivered many international speeches at prestigious institutions and organizations such as the United Nations, funded by various entities, including presidential institutions, the Ministry of Justice, etc. He has published papers on international legal issues, including works published by Organization for Security and Court Operations in Europe. After returning to Japan and working on his doctorate dissertation, Yamamoto participated in COI project and as an integrator led by the president of University of Tokyo. He is now preparing to publish a review worldwide with publishers such as Cambridge University, International Press, IJA Global, Central Asian Legal Research Fellowship, Tashkent State University of Law, the Japanese Institute of International Business Law, etc. He has just come back from international symposium led by the United Nations, the Ministry of Justice, and so on, having delivered the international peace at Tashkent, etc. We welcome you, sir, for this wonderful webinar organized by KFCRI. Next, I would like to welcome Ms. Samina Syed. Samina Syed has been a wonderful colleague she has been working here, and she is now currently holding a position in Volterra Fiesta, which is a leading global law firm in public international law and international arbitration. At Volterra Fiesta, she assists with matter pertaining to core public interest litigation, private international law and international arbitration. And she holds a Bachelor of Law at BA LLB Honors from Tamil Nadu Dr. Ambedkar Law University, School of Excellence in Law, Chennai. She also holds a Master in International Investment Treaty Arbitration with a distinction from Uppsala University, Sweden, wherein she was recognized as a top performing candidate of her class, and she was the first Tamil Indian law student who have graduated from this master program. We welcome you, ma'am, for this wonderful session.
Thank you. Thank you, CP. Professor, I think you can unmute yourself, the audio. You have to unmute your audio.
Yes, sorry about that.
Thank
you
you.
for your
First of all, on behalf of KFCRI, we are very happy to welcome you. And on behalf of KFCRI, me, along with my managing partners, Mr. Shahrukh Kumar, Mr. Shanmugh Dev, Mr. Svetan, Ms. Samina, Mr. Sipi, as well as the Kuwait Foundation founders, we are happy to welcome you. It is wonderful morning or Saturday morning in India and afternoon in Japan and other participants who are spread over the various parts of the world. We are very happy to have an interactive session, a fireside session on the ADR in Japan. To begin with, Professor, we like to know about the existing legal system in Japan and how and to what extent that system has been well suited for all type of disputes, and more particularly, how the shift has changed from the existing legal system to acceptance of alternative dispute resolution, particularly arbitration.
Yes, thank you very much, Honorable Professor Imba-san. And I'd like to show my thankfulness from my bottom of my heart that I can participate in this very important international symposiums. And thank you very much, Mr. Sipi, for your introduction about me. And Ms. Samena-san, who is now in London, who has been trying to manage this international symposiums organizations and dedications, about my preparation for everything to do. This is a very privileged international symposium. Thank you all. Thank you very much, especially Imba-san. Thanks for the very long time, communication with each other, India, Japan, and sometimes other parts of the world. And generally speaking, the Japanese legal systems, as Professor Imba-san suggested, the Japan has a type of continental law type system, as you know. And the public law area, Japan has introduced the American law type after World War II, especially in the field of constitution and commercial law area. But basically, when we talk about the legal systems in Japan, especially in the civil law area, as I said, civil law, it's a continental type of law. So I think the system itself is a bit, different from the Indian type, basically on the base of common law type. So shall I continue or to this extent?
Yes, Professor.
Yes.
We can have a initial bird's eye view on the existing arbitration regime in Japan and the change, the new one.
Yes, thank you very much. The arbitration regime in Japan has been in existence for a long time and has a rich history. Arbitration itself has been recognized and regulated, under Japanese law for several decades. The current legal framework for arbitration in Japan is primarily governed by Act on Arbitration Act, which means the positive law legislation, which was first enacted in 2003 and revised in 2004 and 2006 to align with international standards, particularly the United Nations Commission on International Trade Law, as you know, UN CITRA model law on international commercial arbitration. Japan's arbitration regime has evolved over time to promote a more arbitration-friendly environment. Especially, 2003, 2004, 2006 was a kind of a very special time for Japan to make a, evolvement, the reformation of the legal system of Japan. And from that time, the Arbitration Act incorporates provisions that emphasize party autonomy, provide for efficient and fair arbitration procedures, and facilitate the enforcement of arbitral awards. So if I may continue, furthermore, Japan has established the Japan Commercial Arbitration Association, JCAA, which is very much well known as one of the most Japanese arbitration, the main center, as a leading arbitral institution in the country. The JCAA provides arbitration services, administrators, arbitral proceedings, and has its own set of arbitration rules. In recent years, Japan has made effort to further enhance its arbitration regime to attract international arbitration cases. For example, in 2018, Japan amended its Arbitration Act to expand the scope of arbitrable disputes and introduce provisions on third-party funding. Overall, while Japan's arbitration regime has long-standing history, it continues to evolve and adapt to meet the demands of international arbitration and provide an effective mechanism for resolving commercial disputes. So this is a kind of a general aspect of Japanese arbitration, on the basis of positive law. As I said, if we talk about the arbitration, basically, if we talk about the positive law, it's based on the Act on Arbitration, which was established 2003. So maybe it's appropriate for us to talk about arbitration and international arbitration on the basis of Act on Arbitration 2003. And now, Ministry of Justice is trying to enhance the more of accessibility on the basis of commercial, and it's now it has established the other international arbitration center. So I would like to talk about it, if you do not mind, or if we have a time. So until now, I would like to make it as a short introduction of a general aspect of arbitration system in Japan.
Thank you, Professor,
Yes.
for giving a initial insight about the arbitration regime starting from 2003 and to what extent the party autonomy and the institutional arbitration had a role as an introduction. Moving
Yes.
on, the general understanding is that globally, whether it is a common law system or a civil law system, the continental one, rightly pointed out in the perspective of Japan, whether in Japan, the UNCITRAL, that is the United Nations Commission for International Trade Law, the model law on arbitration has been adopted. How does the law of arbitration pan out in Japan? Can you just give a broader perspective about this law of arbitration, wherein we have multiple aspects, starting from party autonomy to the enforcement? Can we just understand how the law is at par with the UNCITRAL model law on arbitration? Professor, you can unmute your audio.
Sorry. Thank you very much. So, it's a relationship between the ancestral and the civil law, continental, type of law base, Japanese legal systems. So that's what I understood your question. That is okay.
Yes, Professor.
Yes. So in Japan, if I may start, the law of arbitration is primarily governed by the Act of Arbitration, Arbitrary Act, as I said. So this is thought to be a part of civil law type of ADL, like the civil law procedure, ADLs, which provides the legal framework for the arbitration proceedings in the country. While Japan is a civil law jurisdiction, as pointed out, it has incorporated elements of United Nations Commissions on International Trade Law, UNCITRAL, modern law on international commercial arbitration into its domestic legislation. So the Arbitration Act was first enacted in 2003 and has undergone subsequent revisions to align with international standards and best practices in arbitration. These revisions were made in 2004 and 2006 to ensure consistency with the UNCITRAL model law. The Arbitration Act in Japan includes provisions that emphasize party autonomy, as pointed out, allowing the parties to determine the procedures and rules that will govern their arbitration. It also provides for fair and efficient arbitration proceedings and facilitates the enforcement of arbitration awards. Japan's adoption of UNCITRAL model law principles reflects its commitment to creating a modern and arbitration-friendly environment. The use of internationally recognized standards helps ensure consistency and compatibility with arbitration practices in other jurisdictions, not just in a country. Furthermore, Japan has been active in international arbitration and has ratified the New York Convention on the recognitions and enforcement of foreign arbitral awards. This convention facilitates the recognitions and the enforcement of arbitral awards across national borders. Overall, the law of arbitration in Japan, as embodied in the Arbitration Act, provides a comprehensive legal framework for arbitration proceedings. It combines elements of a civil law system with, as I said, international standards, contributing to the effectiveness and credibility of the arbitration process in the country combined.
Yes. Excellent, Professor. It is very clear what you have understood is that the arbitration regime or the law prevailing in Japan obviously is in line with the UNCITRAL one. And the most interesting thing is that the enforcement, particularly the New York Convention, which has been ratified by Japan, that also makes a hassle-free arbitration with its enforcement. Thank you. Professor, moving to the third aspect in this particular chat, I like to know, when it comes to arbitrating a dispute, one of the most interesting aspects that we come across either by law or by the mandate is arbitrability of dispute. For example, as an illustration, in India, by way of rule of law and guidelines issued by the Apex Court, certain disputes cannot be arbitrated.
Mm.
How does this arbitrability function in Japan? Is there any asset or any set of disputes that can be arbitrated either by mandate or law? We like to know in Japan, what are the disputes we can arbitrate and what cannot be arbitrated? Whether we have any such restriction or we can just arbitrate all type of disputes. Professor?
Thank you very much, Ima-san. I think this question can let us think about what the law is, because your questioning will make it very clear what kind of type of dispute will be excluded from the arbitration, and which would think about what kind of law can be handled in the area of arbitration, and what kind of types will be excluded from the arbitration. So in Japan, the principle of arbitrability is recognized, allowing parties to arbitrate a wide range of disputes. However, there are certain types of disputes that are not considered arbitrable based on legal provisions and public policy considerations. Let me provide you with some information on arbitrability in Japan. I would like to point out 4 points. 1, contractual freedom. 2, exceptions to arbitrability. 3, public policy considerations. 4, judicial intervention. The first are contractual freedom. Japan places a very strong emphasis on party autonomy and contractual freedom in arbitration. As a general principle, parties are free to agree to arbitrate any dispute arising from a contractual relationship. This includes commercial disputes such as those related to international trade, construction, finance, and intellectual property. But second, exceptions to arbitrability, as Professor Ima-san pointed out, while parties have a broad discretion to those arbitrations, there are exceptions to arbitrability based on legal provisions and public policy consideration. For example, disputes involving criminal matters, family law, and certain administrative matters are generally not considered arbitrable. So kind of the element that has public interest and criminal and family. Family, if we talk about family, it's important, how the constitutionalism and public law elements are, if we talk about law. So those are excluded from the arbitrations. And as I said, public policy considerations, we have to point out the concept of public policy plays an important role in determining arbitrability in Japan. Even if parties agree to arbitrate a certain dispute, the court may refuse to enforce an arbitral award if it violates the fundamental principles of Japanese law, or mainly when we talk about this, public policy. This ensures that certain matters of significant public interest are not subject to arbitration. The fourth point, judicial intervention. In some cases, the court may intervene to determine the arbitrability of a dispute. For example, if a party challenges, it's okay. For example, if a party challenges the validity or scope of an arbitration agreement, the court may decide whether the dispute is arbitrable based on the specific circumstances of the case. So, overall, while Japan recognizes and promotes party autonomy in arbitration, there are limitations on arbitrability based on legal provisions and public policy consideration. It is essential to carefully examine the relative law and seek legal consideration a little bit more. Thank you very much.
Yeah, thanks, Professor. It was a clear picture about the arbitrability in Japan, the 4 principles what you mentioned, which is in lines with the ancestral model law. And we are quite happy to understand that Japan also is on that path, accepting these basic principles of party autonomy, the acceptance of the parties, the public policy, as well as the judicial intervention, wherein the courts also has the right to determine whether it is arbitrable or not concerning certain disputes.
Yes.
Moving to the next aspect, that's a 4th one. In the current scenario, we see that more parties are opting for institutional arbitration. We can see jurisdiction like India, Singapore, or even Middle East, Dubai. Much of institutional arbitrations are considered to be preferable arbitration over ad hoc arbitration. What is the trend in Japan? Whether the parties are more affiliated with ad hoc or institutional arbitrations. I think earlier you just mentioned about JCAA, that is a Japan Commercial Arbitration Association. And we do have this Japan Maritime Arbitration Commission. Multiple arbitrations are there in Japan. What is the present trend of institutional arbitration in Japan? Can you just share with us the actual reality in Japan regarding institutional arbitration?
Yes, thank you very much. I reply to you, Professor Imba-san. Yes, thank you for your questionnaire. To make it short, the questionnaire, whether ad hoc or institutional, the answer would be the trend is going to the direction of institutional, if I may, answer the question very quickly. So a little bit more on the sentence, if I may continue. In Japan, there has been a noticeable trend towards institutional arbitrations, rather than ad hoc arbitration in recent years. While ad hoc arbitrations still exist and are utilized in certain cases, institutional arbitrations are becoming more popular among parties. One of the main reasons for this trend is availability of well-established arbitration institutions in Japan that provide comprehensive arbitration services. The Japan Commercial Arbitration Association, JCAA, is one such leading institution in the country, Japan. The JCAA offers administrative support, rules, and facilities for arbitrations, making the arbitration process more efficient and reliable. Parties, often choose institutional arbitrations because they provide a structured framework and established rules for the conduct of proceedings. And these institutions have experienced case managers and administrators who assist parties in managing the arbitration process, facilitating communications and resolving procedures issues. This can help parties save time and resources, ensuring a smoother and more predictable arbitration experience. Additionally, institutional arbitrations offer a level of expertise and specialization in handling complex international disputes. The arbitral institutions typically have a roster of experienced arbitrators with diverse backgrounds and expertise, allowing parties to select arbitrators who are knowledgeable in the relevant area of a law or industry. While ad hoc arbitrators are still used, particularly in specific cases where parties prefer more flexibility and control over process. That trend in Japan is gradually shifting towards institutional arbitrations. The availability of established arbitral institutions, their support, their support services, and the advantages, they offer in terms of efficiency, expertise, and the credibility contribute to the growing preference for institutional arbitrations among parties in Japan. Thank you.
Professor, thanks
Yes.
for the highlight about this paradigm shift from ad hoc to institutional, which is a common trend not only in Japan, outside Japan also. We are
Yes.
quite happy to hear that the same thing is going to apply in Japan, wherein institutions like JCAA and other arbitration institutions are going to facilitate institutional arbitration. Thanks for that information.
Thank you.
Professor, now I like to ask my colleague, Ms. Samina Syed, to facilitate the other discussions which we have already forecasted, which is all expected by the audience to further understand about Japan and arbitration. Samina?
Thank you so much, Indovigian sir, for giving me this opportunity and molding me to become the person that I am today. And I'm very glad to meet Professor Kazushi finally online. It's a great morning, especially when we talk about such thought-provoking conversations, especially on what is the current regime in arbitration. Professor, as we speak, something that sparks in arbitration whenever we have a conversation with an academic or a practitioner is the concept of seat of arbitration. This is much deliberated and also very much discussed, not only by the parties who choose them by way of party autonomy or the councils who practice in a respective jurisdiction. And I've come across most oftentimes than other, these discussions lead in a manner that will always end up in the topic of how much of a court interference will a particular national court have over the arbitration or domestic or international happening in that particular jurisdiction. So in light of this, can you tell us if how much of a court interference is present in arbitration activities in Japan, and the follow-up to that is Japan, as you mentioned, an arbitration-friendly regime for international arbitration, and has it been accepted as a seat for disputes?
Amanda-san, the question is to me, to answer the number
Yes,
of
yes.
a percentage or cases that the court itself, would be, interfering to the, arbitration agreement. So, to be honest, I don't know the exact number of the percentage of, arbitration cases where the court, has actually interfered to the agreement of arbitrations, but I can give you the feedback, the exact number. But actually, the Japanese constitutional system has a strong the guarantee for the civil law, the very autonomous system. So basically, if it doesn't, I mean the arbitration itself and the arbitration agreement would not violate the principle that I have mentioned from the point of view of 4 points. I don't think the court itself would be very easily, flexibly interfere the arbitration or arbitration agreement. I don't think so. And I'm sorry that I cannot answer to you by the very exact number, but basically, Japan has a constitutional principle to guarantee the civil autonomous the economical system. So the court without any reason do not interfere the arbitration. This is my understanding.
That's very interesting to know because it encapsulates what arbitration in Japan is. Professor, moving forward, another highlight that comes across to everybody when we speak about arbitration is one of the two key elements, that is fairness, that is established through the arbitration process, and confidentiality as an aspect or a mandate in arbitration. How are these two key elements reflected in the arbitration practice in Japan?
Yes, Mr. Mena-san, this is a very important aspect when we talk about the arbitration, because if people will disclose the information of arbitration, nobody will trust the arbitrators and the arbitration systems, confidentiality. So that's a very important point. Basically, if can I speak a little bit, if you don't mind, that would be a little too long for the answer, but in Japan, fairness and confidentiality are indeed, key elements, that are highly valued and are reflected in arbitration practice. Let me explain, how these elements are upheld in the arbitration process in Japan. Fairness, due process, and procedural flexibility. The last one, procedural, flexibility, that is, a little too much. So, impartial arbitrators, upon the concept of fairness, the selection of impartial and independent arbitrator is crucial in, ensuring, fairness in arbitrations. Parties in Japan have the freedom to choose arbitrators who are neutral and unbiased, and who possesses necessary expertise in the subject matters of the dispute. So, if I may, continue, due process. Also, the arbitration proceedings in Japan follow principles of due process and provide equal opportunities for both parties to present their case. This includes the right to be heard, present evidence and cross-examine witnesses. The parties, have opportunity to present their arguments and evidence, and the arbitrators, consider them in an objective manner and a fair manner. So I think those elements that would be, very fit to your questioning. I hope so, Ms. Samena-san. So I give you back.
I mean, it's very interesting because it's the very same manner or procedure that we see across the globe as well. Professor, thank you so much for answering. So this directly leads me to my next question. There's a famous saying that goes around in the world of arbitration is, it's once you get the award, it's not the actual victory. The real battle starts only during the time of enforcement, because enforcement during an arbitration proceeding is very crucial. And most often than others, especially in jurisdictions I come from, it's always challenged. And this gives us a broad range of views or ideologies, both amongst practitioners and academic, and the regime in itself. So could you briefly tell us how is the enforcement and challenge regime go about in Japan?
Yes, I think that's a very important aspect of arbitrations, because the arbitration itself, basically based on the autonomous will of the parties. So how can the dispute can be, the facilitated and the judged, as final decisions? That's a very important aspect. So the challenge and the enforcement of arbitration awards in Japan are governed by the Arbitration Act. And as I said, at the very beginning of my explanation of arbitration system, and related, legal provisions. Shall I continue a little bit, Samina-san?
Yes.
So yeah, if I may, let me explain the regime for challenge and enforcement in Japan. So first, the challenge of arbitration awards. The first, set aside proceedings under the Arbitration Act. a party may challenge an arbitration award by filing a set-aside proceeding with the court. The grounds for setting aside an award are limited and include situations where the arbitration agreement is invalid or not binding. The party was unable to present its case due to fundamental procedural defect. No, I will omit the following point. The second, in a time limit, the set-aside proceeding must be filed within the 3 months from the date the party receives the arbitral award. And third, judicial review. The court reviews the challenge, based on the grounds specified in the Arbitration Act. The court's review is limited to examining, procedural irregularities and ensuring, compliance with the requirements of the Arbitration Act, rather than re-evaluating the merit of the case. And as you pointed out, it's about enforcement of arbitration awards. And I would like to point out the 4 points. The first, voluntary compliance. The second, enforcement proceedings. 3, a New York Convention. 4, grounds for refusal. So first, voluntary compliance to enforce. In many cases, parties, voluntarily, comply with the arbitration awards without the need for enforcement proceedings. When a party fails to comply voluntarily, the winning party may seek enforcement through the court. The second, enforcement proceedings. The winning party can initiate enforcement proceedings by filing an application with the court. The court reviews the application and, if satisfied, issues an enforcement order to enforce the award. The third, New York Convention. Japan is a signatory to the New York Convention on recognition and enforcement of foreign arbitral awards. This convention, facilitates the recognitions and enforcement of foreign arbitral awards in Japan, subject to limited grounds for refusal. Fourth, the grounds for refusal. The court may refuse to enforce an arbitration award in limited, circumstances, such as when the award has been set aside by the competent authority in the country where it was rendered. The second, the arbitration agreement was invalid, or the party against whom enforcement is sought was not given proper notice of arbitration proceedings. So there are many cases as to the grounds for refusal, but I would like to omit a little bit. So can I give you back, Sameno-san? Thanks for your questioning about the mainly enforcement of arbitration, which is a very the strong and the topic we should talk about.
Thank you so much, Professor, because it really encapsulates everything under one umbrella. Now, as we speak about enforcement, we see a cultivating trend in acceptance towards emergency arbitrations across the world. For example, in India recently, the Supreme Court said we would thereby accept emergency arbitration decisions, and then we go for enforcement. So how does emergency arbitration play a role in Japanese arbitration, and how are the decisions rendered by emergency arbitrators enforced?
Yeah. So emergency. Sameno-san, so if I may, can I change the topic if you don't mind?
Oh, absolutely.
Yeah.
So the follow-up to that
Yeah.
was so the following up to that question was,
Yeah.
when we think about international arbitration in general, one thing that comes to us, or it's a new venture or a fascination to many, including myself, is investment arbitration.
Yeah.
For example, recently, a very famous case of Nissan versus India came up, accruing
indeed.
from the Indian and Japanese BIT, but later it was settled. So these are the knowledge that we have about investment arbitration trend in Japan. But can you talk from your experience, either in research or practice, or talking to your other practitioner colleagues, how does investment arbitration regime play about in Japan?
Yes, I think that questionnaire, the topic is a topic, most of our colleagues here would be interested in. Especially, I hear that the trend was, investment from Japan to India. But these days, many people are interested in the investment from India to Japan also. So many of you are interested in this topic. So I really would like to, answer this questionnaire. Thank you very much, Samina-san. So as it is very much well known, there was the case Nissan versus India. So it's about the international investment and also the arbitration. So if I may, continues a little bit, Japan has been, actively involved in the field of investment treaty arbitration and has developed a comprehensive investment arbitration regime over the years. So the country, has signed numerous, bilateral investment treaties, BITs, with other nations, which provide a framework for protections of foreign investments and the resolution of investment disputes. Japan's investment arbitration regime is primarily governed by the Arbitration Act of Japan, which incorporates the United Nations Commissions on International Trade Law, Citral Model Law on International Commercial Arbitration. This ensures that investment arbitration proceedings in Japan follow established international standards. One notable aspect of Japan's investment in arbitration regime is the Japan Commercial Arbitration Association, as I said, JCAA. The JCAA is the leading arbitration institution in Japan and provides administrative support for both domestic and international arbitration cases. So this is a little, same as I mentioned. So when I skip to the Nissan versus India. And regarding specific, investment arbitration cases involving Japan, the case you mentioned, Nissan versus India, is indeed, significant. It involved a dispute between Nissan and the government of India and the Japan-India BIT. The case arose from a tax dispute, so it was in the field of tax and disputed, and related to Nissan's investment in India. While I don't have information on the settlement you mentioned, it's worth noting that the case exemplifies Japan's engagement in investment arbitration and its use of BITs to protect the interest of its investors, abroad. And furthermore, Japan has been an active, participant in the negotiation and signing of multilateral agreements related to investment protection. For instance, Japan is a signatory to the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, as you know, CPTPP, which includes investment protections provisions and the mechanism for investor-state dispute settlement, ISDS. Overall, Japan has a well-established investment arbitration regime that encompasses both domestic and international arbitration cases. So Japan has a well-established, ad hoc and mainly these days, institutional administration international arbitration system as to international investment from the foreign countries. So when I give it back, Samena-san, thank you very much for your question.
Thank you, Professor, because it is very interesting to talk about investment arbitration in the case you mentioned, because as an highlight, it actually accrued from the place where me and Inbavijin sir hail from. It actually accrued from Tamil Nadu, then got into the government of India, and then the case happened. Very interesting to know. Professor, I think we are almost at the end of our session and our wonderful fire chat. Before we conclude, do you have any final thoughts that you would like to share on the arbitration regime in the perspective of international arbitration regime in Japan?
Yes, since especially the era of 2000, Japan has been, tried to establish the very regime. In Japan, from the point of view of civil law, civil procedure laws systems, it has been called like the ADR, especially. But from those eras, my perception is that Japan has been very keen on to establish the international investment and international arbitration systems in Japan, including establishing the law school system in Japan. So anyway, Ministry of Justice, has launched the establishment of a new act, about arbitration system, which is called, if I mention right now, if I can show, yeah, it's a very long sentence, the act, 2003, April 28th, Ministry of Justice, also announced the new acts, about the arbitration law system. So Japan is very much, keen on establish the arbitration, friendly system, including the international investment and international arbitration. That is my perception about the arbitration from the terms of ADR.
That's completely very interesting to know, because as of all of now, we were just knowing about international arbitration regime happening through either papers or books. It was very interesting to speak to you on real time on what are the nuances and the nitty-gritties that is involved in international arbitration in Japan. I think now I would like to pass on the floor to Professor Inbavijin if he has any remarks to ask or comments to make on the arbitration regime.
Yeah.
Yes.
Yes. Well, Samina, thanks for facilitating the conversation with Professor. Professor Kazushi, it was very interesting to hear the arbitration regime, more particular with the ancestral model law, as well as to the acceptance of the New York Convention and the present trend of the investment treaty arbitrations. What is a value addition, what you feel for practitioners and professionals who wanted to actually get involved in the ADR process in Japan? How we have to be equipping ourselves? What are the prospects we have as professionals getting into ADR, either in Japan or wherever the Japanese the contractors are getting involved? Whether it is the Far East, or whether it is going to be the Middle East or beyond Asia. What is your thought about the professionals getting involved in ADR?
Thank you very much, Professor Imba-san. So your question is, how the Indian professionals, can get involved in, Japanese, arbitration system, or more broadly, how we can do together in the area of
The
international
second
arbitration system.
Yeah, the second part.
Second part, yeah, and that's a very interesting topic we talk about. Okay, well, as you know, the Singapore is a very internationally well recognized, arbitration place. Maybe, rather than Tokyo, right now, Singapore is a very well known for the arbitration system. And also Dubai, of course, now as you mentioned, and India might be the very strong place for the international arbitration. But anyway, maybe we need, from the point of view of modern law, the government, may or be able to, support the facilitations of areas systems, and from the terms of that system, we can facilitate the system of arbitration itself. But furthermore, what is very important thing, for us, professionals, maybe the belief in the civil laws or civil societies autonomous, how to say, agreement or autonomous, activity shall be protected, from the terms of constitutionalism internationally. Would be very the good point. Maybe we can focus on, or we can take it very important. This is my perception from the global, economical aspect. This is my reply to you. But what do you think about it, Imba-san, from your side? Thank you very much.
Yeah, amazing analysis, Professor. Now I think we have to give the opportunity for participants, if you are quite interested, to get some information about this particular session and ADR in Japan. Participants who wanted to get clarifications from Professor regarding ADR in Japan, you can just place the questions in the chat box so that it can be shared with the Professor for his expected answers regarding this ADR in Japan. I think already I got a message from honorable colleague Dinesh Bisnaj sir. Thanks for so much for the kind initiative and grateful as ever for the insightful session. All the credit goes to Professor Kazushi for sharing a bird's eye view about ADR in Japan, which has to be very well appreciated. I feel that you have reached the entire part of arbitration and ADR and how it is working, the concept of ADR in Japan, and what is going to be the future. I am very thankful on behalf of KFCRI. I request my colleagues, both Ms. Samina and Mr. Sipi, to give the closing remarks for this wonderful session done by Professor Kazushi. Samina?
First of all, thank you so much, Professor Kazushi, for taking out time from your busy schedule. And I know that how we have been coordinating over the days and how difficult it was. But thank you so much for all your patience and for making time to come and speak to us on a very important regime discussion that we've been having on Japan. As I mentioned before, we've only read about Japan either in books or research articles. It was, when we hear from you, it is really astonishing and it also quite thought-provoking. And I would also like to take a moment and thank Professor Inba for giving me such an opportunity to speak from all the way from London to all of you present here. And also I would like to establish my gratitude. Because of him, I've come to places like London. So thank you so very much for your time. And I absolutely enjoyed the discussion because it is very important for us to know what are the regime developments or nuances that is involved in every jurisdiction to practice our arbitration, either both in an academical manner or in a very practitioner manner. So thank you so very much to both of you. Now I would like to hand over to Sipi to make his conclusions on the event.
Thanks a lot, Samina.
So I would like to thank Professor for before you today for felt this immense gratitude and deep sense of appreciation to deliver sort of thanks on behalf of KFCRI. First and foremost, I would like to extend our heartful gratitude and to our esteemed speaker, Professor Kazushi. Your profound knowledge and expertise and engaging presentation styles actually captivated us. The way you eloquently shared your insights and experience on the bird's eye view on arbitration in Japan just made an indelible impact on each participant. I hope so. And we also extend our sincere appreciation to the organizing committee and for their timeless effort in planning and executing this wonderful webinar. Thanks a lot joining for this session, Professor.
Thank you very much, Sipit. Sipit-san. Thank you very much for your remark. And first of all, thank you very much, everybody, for your participant during the very busy time of your life and share of your very precious time of your life. Thank you very much, and I'm very much appreciated with this very privileged, opportunity, and that I'm thankful to the fact that I'm able to meet you, all of you, through this opportunity. Thank you very much. And first, yeah, Imba-san, sorry.
Sir, you're on mute.
Imba-san.
Yes,
yep.
yes, I unmuted. It always happen. And we are grateful on behalf of KFCRI to Professor Kazushi Yamamoto. And interesting information to all, including KFCRI team members and the participants, is that Professor Kazushi is living in a place where the great Suzuki factories wherein we enjoyed the 70s and 80s, the Maruti Suzuki vehicle, which made the revolution happen regarding the automobile industry in our country, particularly in our state. Predominantly, I also personally started with a Maruti vehicle. There's a Maruti Suzuki joint venture. And we are very happy to have with us Professor Kazushi, who comes from that particular, and the relationship what had between Indian government and the Suzuki Motors, that also would establish the KFCRI connection with Professor Kazushi. That's the final words I want to share. And thanks, Professor. And our relationship should be in a long term, so that the KFCRI members and participants who really enjoy this session would eventually take this as a first step to get into the relationship between India and Japan, which is natural, obviously, but still it has to go on the legal perspective also.
Thank you very much, Professor Imba-san. And thank you very much again for your goodness to me and for these opportunities again. Thank you very much. And me too, this relationship, I'm sure, will be lasting very long, and we can do very much, cooperation internationally. So I believe in you, and I believe in him. Our mutual, cooperation for the better future, and to do good things to the global world.
Okay, bye to all participants, and thanks for the entire team joining. Thank you.
Thank you.